thank you all for joining. In a minute, I will introduce my my guests, but before I do that, I wanted to just make sure that you're all here for the right topic. Today, we're talking about the main differences between getting divorced in France and getting divorced in England. Just to be clear, not everybody has that choice. So it's important to check whether you do, but if you have ties to both countries, you may be in that unique situation where you can choose where to divorce. And that's where understanding the implications of that decision is going to be really important. I find with my clients, I work a lot with French people who are abroad, a lot of them in the UK. And this is usually quite an overwhelming conversation and decision to make. And, you know, it feels in a lot of ways that it's the biggest one. And it's certainly one of the earlier ones they have to make. And so we spend a lot of time discussing this, and getting advice from a lawyer is key in this process to really understand what the possible outcomes would be in each country. So in making this decision, there's a lot of things to consider. Definitely what the laws are in each country and which one is likely to give you the best outcome based on your situation, but also how long it takes to get divorced in each country, how much it might cost, what requirements are in place. Some countries have waiting periods, different grounds for divorce. So gathering all of that information is really key in making that decision. And what we wanted to do today is to give you kind of a whistle-stop tour and give you an overview of some of the main differences between the two, so that you can at least have a beginning of an idea when you're making this decision if you get to that stage. So to discuss this topic, I've invited two lawyers from either side of the English Channel. Rachel Freeman is a solicitor in England. She works at Burgess Mee, and she's got over 20 years experience working on divorce, children matters, financial matters, and mostly on international cases. And Coline Le Cam-Mayou is based in Paris. She is a lawyer in France, and she's got years and years of experience as well, working in both French and British international family law. Welcome to both of you.
Thank you.
Thank you, Chloe.
It's great to have you here. So before we dive into the meat of the matter, I think it would be good to do a bit of level setting. So, you know, all of the differences that we're going to discuss today are very much linked to the cultural backdrop that we see in each country. So there will be different approaches to how you apply for divorce. So the grounds for divorce will vary, but also the legal culture is different in both countries. So I'd love to start with that kind of level setting. And maybe Rachel, you can tell us first how it works in the UK in terms of getting a divorce, and then we can talk about France with Coline.
Thank you. So getting the bit in England, you can be divorced. You don't have to deal with the arrangements for the children or finances. It's absolutely finances as well, financial settlement, but you can be since no fault divorce, only no fault divorce. So that,
Rachel, sorry, I'm going to interrupt you. Your sound is coming in and out.
I was wondering if I was the only one.
It wasn't just you.
Yes. Sorry,
I'm not sure why it's a bit choppy.
Okay, I'll try again. Is that better?
It seems to be.
Yeah.
Okay, closer.
Sorry, if you don't mind starting again.
So, yes, England's a self-contained process of divorce. You can be divorced without having to sort out finances or the arrangements for the children, but it's always absolutely recommended to sort out your financial settlement at the same time, of course. Since April 2022, so 2 years, we have divorce in England, which was a really big step. Because before that, the reason for the same, so that the relationship has been broken down, but people have reason or live apart for 2 years or more. So this is a really big step, and it means that less harmonious. You even have a joint application if you want to, if that's your divorce. I don't recommend if there is a choice of jurisdictions today, because you would need to take line up get your ducks in a row before you file a petition, or I mention divorced with the other spouse. Make sure that you're in the country that's the best for you. But yes, it's very straightforward now, and it's difficult to end it. Well, no, I haven't behaved unreasonably, and that's all gone now. So it's the start of it a lot easier.
Thank you, Rachel. You're still very choppy. I'm not quite sure what's going on. The essence of what Rachel was saying is that since April 2022 in the UK, in England, there is an option. Well, the only option to divorce is no fault divorce, as in you do not need to really have grounds for divorce. As long as you think that the marriage is irretrievably broken, you are allowed to apply for a divorce. So really the notion of grounds for divorce no longer exists in the UK.
Do you want me to talk about the ground for divorce in
Maybe,
the meantime?
Exactly, if you don't mind.
Because
I know
Rachel knows already what I was
exactly.
So there is a lot of differences between our two systems, obviously, but this is one of the big difference. In French law, we still need a ground for divorce. In the French Civil Code, there is 4 specific grounds provided. There is the mutual consent divorce. It can be an in-court divorce or an out-of-court divorce. When it's an out-of-court divorce, it's a divorce with a notary. I could talk a lot about that, but there is a lot to do. So if you need to know more, I can talk about it later. Another ground for divorce is the separation of the couple, at least since a year. Another ground is the agreement of the spouses on the principle of the divorce, but not on the consequences of it. It means that they can agree on the divorce itself, but they disagree on the consequences regarding finances or children. And hi Rachel, how you again?
Hopefully it'll work now.
And in this case, it can be a joint petition too, if you agree on the principle of the divorce, and the procedure will be on the consequences only. And the last ground for divorce is the fault. So there is a fault when there is a break of one of the obligations raised from the marriage. The marriage obligation in the Civil Code are respect, fidelity, aid and assistance. And a break of it could be, for example, infidelity or violences, etc. So this is our 4 grounds for divorce. And another big difference with what Rachel said is that in France, when you file for divorce, the court will have to sort out every matter in the same process. So we will deal with the ground for divorce. We will deal with the financial consequences and the consequences toward the children. And if there is one child in the couple, the question regarding the children will be dealt during the procedure. You can't avoid it. It can be about the organization of the life child or about the maintenance. But children, finances, and ground for divorce will be in the same process.
Thank you, Coline. Rachel, hopefully we can hear you now. I hope this has solved it.
At least it shows it's live.
Yes, definitely live. We've had all the hiccups. So we were talking, we had a couple of calls preparing for today, and we were talking about the many differences between the 2 jurisdictions, but we felt that it boiled down to about 5 major topics. The first one is financial disclosure, which is handled differently in each country. The second is prenups, or contrats de mariage in France, pensions, spousal maintenance, and child maintenance. So I suggest we run through the list, and I'm sure it'll bring up other bits that are different as well. But those are kind of the five main elements that we boiled it down to. So maybe let's start with the financial disclosure process. And Rachel, we're going to test your microphone and see if we can understand from you how it all works in England.
Okay, let's go. How does that sound?
It sounds like it might be choppy.
It's working.
Go for it. Give it a try.
Sorry, I was really near to my phone. Sorry. So the disclosure process is very thorough. The standard way that spouses or the civil partners have to fill out Form E shows everything they have worldwide, all assets, debts, pension, income, and they have to provide supporting documents as well. So bank statements, pension statements, returns, P60s, all of this, and then they swap it, and parties can ask further questions. And if there's assets that are valuing, so property or companies, for example, we can instruct the court can instruct an expert valuer to value, and it's a really thorough process. People disclose everything, and if they disclose everything, and it turns out in a few years they didn't, and it makes a difference. The settlement can be reopened. So there's a real onus on this first stage, really thorough.
Thank you, Rachel. It was still a little bit choppy, so I'll just summarize what you said. So in England, there is a formal process for financial disclosure where both parties have to complete a form called Form E, and they have to provide supporting information. Rachel, can you just clarify whether this is a mandatory process or optional?
The parties can agree to do it voluntarily, but if they start the court case against each other, so if they issue Form A and start the court timetable, the compulsory process, there can be sanctions if they don't complete or if they don't provide proper.
Thank you. Coline, do you want to tell us about how it works in France?
Yeah, very differently. There is no legal disclosure process in France. Of course, if you're divorcing in court or out of court, you have to disclose your asset and income. But we don't have sufficient coercive and enforcement tool in French law. So in one of the party decide to lie or to hide some asset or income, it could become very hard to find it. So we can use some process to find some clue and try to enlighten the court. For example, find the bank account owned under the party's name in France, or the assets owned under the party's name in a specific country in France, or ask to the tax services the amount and the income. But to do that, we need to know that there is asset existing, and the problem is when there is asset in a foreign country, or if the assets are owned under company's name, so shell company, holding company. It makes it very complicated to have a global picture of the other party assets, and there is no sanction in French law if one of the parties is not transparent.
That's really helpful. So a very different approach, and enforced very differently as well. So
yeah, lots of people quite such a different obligation between the two countries.
And I think it's something that people often take into consideration when making this jurisdictional decision, because if there is a fear that their spouse or their soon-to-be ex might be hiding assets, the disclosure process provides some comfort around that. It's not foolproof, but it definitely allows them to gather the information they feel they need to make the right decisions. So the second part we mentioned was prenups, and in France they're called a contrat de mariage. And while they're signed at the same time and with the same intent, they're handled very differently. So Coline, could you tell us a little bit about how they're handled in France?
Yeah, so in France, as in the UK, you can have a prenup or a postnup if you didn't do it before the wedding. And in the prenup, you will choose one of the legal matrimonial regime provided by the civil code, the French civil code, of course. And there is the more famous matrimonial regime are the separation of assets and the community of assets. Maybe I need to say that if you don't have any prenup with a choice of matrimonial regime, the legal regime applicable to you will be the community of assets if you live in France after the wedding. But there is different regime existing in the civil code. In the prenup, you will just have to choose one of the regime, and sometimes some provisions regarding the contribution of the spouses to the household expenses. And you can make some choices of law and of jurisdiction, but that's all. There is no provision regarding the potential financial compensation in case of divorce, and there is nothing regarding children in the prenup.
How does it get enforced at divorce time if it so happens?
Going to it. In case of divorce, the prenup will be fully respected by the French court, and there is the court has no discretion on that matter because there are rules in the civil code explaining how the liquidation of assets has to be. So if you decide to be under a separation of assets regime, your assets will remain separated after the divorce.
Yeah, that's really helpful. Thank you.
Very secured regarding, the will of the parties is very important in French law. So because it's in the contract, it will be very strongly respected.
So that's very different to the English approach. Can you tell us a little bit about that, Rachel?
That is very different from the English approach. And I noted when Coline said there are rules in France, and we do have rules, but we have a lot. The judges have a lot of discretion. So we don't have a matrimonial regime in England. It's a discretionary system based on the statute, so the Matrimonial Causes Act and case law. So every case is different. It's decided on its own facts and decides what's fair, open to people. Most do reach an agreement rather than going to court based on what the case is and what we think a judge is likely to order. But at the end of the day, the judge has wide discretion, and different judges have different views as well about what's fair. So following on from that, it means that prenups aren't automatically upheld. You can't oust the jurisdiction of the court. It always has to have exercise its discretion and see whether it's fair. People are entering into prenups increasingly now, I would say, and postnups. It's only since 2010 that they've formally recognised, really, then that changed the prenup is fair. The court is very likely to uphold it. Don't have a strict definition of what's fair, so still that basically if the prenup if full disclosure, so that would mean at the entering into your prenup postnup, you have to tell the other spouse what your assets are, what your financial position is. It's to be divorced, but you have to tell them everything, because otherwise that risks the prenup not held at a later stage, given the full and frank disclosure, and the other person know what they were giving up by entering into the prenup. Parties need to have legal advice, and they need not to be under any pressure to enter. And they will be they're very likely they meet all those requirements, but they do need to be fair. That would have to come from Parliament. We're not there yet.
Thank you, Rachel. That was still a little bit choppy, but hopefully everybody got the gist of what you were saying.
Sorry.
I'm not sure why it's doing that, but what Rachel was explaining is that in the UK, in England, it is very much up to the discretion of the judge. There are some criteria that are looked at to validate that the prenup should be applied, but still the judge will always look at whether it is fair, and they may decide that it isn't and not apply it. So it's not at all the same approach as France, which applies the rules to the, exactly as written in the code. In England, it is very much a discretionary power of the court. Should we move on to pensions? So now that's one that often leads to a lot of contentions in England. Rachel, I will give you the mic again, and hopefully we will hear you a little bit better. If you can tell us a little bit about how pensions, so retirement pensions, are treated in England. Okay,
well, I'm coming, Mike. I hope that's a bit better. So, England, we have the court has the pension sharing orders, means that a pension belonging to one of the spouses can be shared, it can be split, and all of the fund or a certain percentage of the fund can be moved to the other party's name or for another pension. Pension companies have a department which depends on and provides a statement when, as part of the party's financial disclosure, a cash equivalent value, and we normally instruct a pension expert, sort of accountant or actuary, to work out what sharing of the pension would be. So it's treated as another asset in the divorce. It has to be disclosed, and it can be shared.
Thank you. Coline, how does it work in France?
I'm sorry, I didn't hear everything you said, Rachel, but I think I know already the content. So the pension in France are taken into account in case of divorce, of course, but differently from the other assets. It depends. It's very complicated to talk about it in a few minutes because it depends of your matrimonial regime. For example, if you the pension are always belonging to one of the spouse, and they are not shared in case of divorce. But if you are in a community of assets, and if the community financed your own pension, it will be counts on reimbursement and money transfer between community and this spouse assets. And if you are, for example, in separation of assets, your pension remains your pension. And it could be, but not always, depending on the ages of the spouses, taking into account in something we didn't talk about yet, is the amount of the prestation compensatoire, and as your asset or as your income if you are close to the retirement. And maybe I should say a few words about the prestation compensatoire. Or
yeah,
I'm not in
that's
the
our next agenda item. So if you want to go for it, you might as well.
Okay, thank you. So I talk about the separation of the liquidation of assets with the prenup respected in France, but we still have a part of discretion of the court and of equity at the time of the divorce. And it's with the prestation compensatoire, which is a financial compensation due after the divorce only. And there is legal criteria to determine if it should be a prestation compensatoire or not, how it should be calculated. So the criteria are, for example, the age, number of children, any career sacrifices, sickness or condition, a lot of criteria, the length of the wedding, of the marriage, etc. But the amount of the prestation compensatoire is always complicated to value because there is a big part of discretion of the court. As Rachel said regarding the separation of assets in the UK, it will depend from a court to another, from a judge to another at least. And the principle is that this is a lump sum. One, the wealthier spouse will pay to the other at the time of the divorce. It can also be monthly payment, but in a maximum of 8 years, or a right of poverty on some assets. In more exceptional situation, it can be a monthly annuity, monthly payment forever until the spouse die. But only if the party who receive the prestation compensatoire is old or sick. It's quite rare.
Okay.
And in this case, pension could be taken into account. That was the beginning of the topic.
Yeah. So in England, it's called spousal maintenance, and it's dealt with very differently. Rachel, could you tell us a little bit about spousal maintenance and how that all works?
Yeah, I'll just tell you a little bit in case I'm still having sound problems. So sorry about that. Spousal maintenance is dealt with, quite different in France, surprisingly. It can last forever. It can be on a lives basis, or it can be made for a specific term, or not at all. It's based on need. So whether the vulnerable party needs maintenance, they will prepare their budget. The court will look at what they earn themselves to contribute towards it, and then it will look at when that party might become financially independent. If it could make a joint lives order, and that means that on a change of circumstance, the other party back say, okay, I've retired now. For example, we need to end that order. So that's the difference. Actually, another difference in English law, maintenance is always variable on a material change of circumstance. So if somebody loses their job or starts earning lots more money, or the other person in receipt of maintenance gets a job or earns more money, it can be varied. And so there are quite a lot of variations as well on through the court.
And it's usually paid as a monthly payment rather than a lump sum like in France, right?
It's usually paid as a monthly amount. The court has to look at whether it can be capitalised so that the parties can have a clean break, because ideally the court wants the spouses to have a clean break. So if someone has lots of money, then it could be capitalised. Often on a verification and termination capitalised, but that, I'd say in the vast majority of cases, is paid on a monthly basis.
And it's indefinite, you said?
It can be indefinite. That is becoming less common, say. That's called joint lives when it's indefinite. I'd say tries to put a term on there. There is much pressure on the other party to be financially independent these days, but or have a term to, for example, when the other parties or when the pensions kick in. Yeah, in some situations, awards are made.
Okay. But there isn't that limit that Coline mentioned in France of 8 years max.
No, absolutely no limit. Absolutely. It's very difficult. It's very specific.
Okay, that's really helpful. So another important difference between the two. And then the last one we were going to touch upon, which is related, and one that usually leads to a lot of conflict at the time of divorce, is child maintenance. And so maybe Rachel, you can tell us a little bit how that's decided upon in England. So how do we calculate it, and how does it get enforced?
So in England, if both parents live in England, then the court of call is not the court; it's the child maintenance. And if the parties can't reach an agreement, the person who wants the maintenance has to apply to the child maintenance service, and they'll do an assessment. Calculation should be they have access to a lot of financial information about people, so they'll be able to say what that person's income is, what they ask that person, and they do a specific calculation based on how many children are involved and how many the children spend with each parent. And there's a very useful calculator online on the child maintenance service that people can look at. Now, if one of the parents is abroad, or they are paying part is more than 6,000, or it's an application for something like school fees, then the person who child maintenance can apply to court. The court will look at it and has a lot more discretion as opposed to the specific formula.
So the child maintenance service is kind of an independent body that helps to administer all of this, and this calculator is applied quite rigorously if somebody applies to the CMS for support.
Yes, it is. There's a next stage. You can go to a tribunal if you want to put in further information, but at the first stage, it's applied pretty rigidly.
And is that the same, Coline, in France? Is there an official body that regulates all this?
No, it's not the same at all. Because as I explained, when you divorce, you will have to discuss about the child maintenance if there is a child. So it's an agreement, or if it's in court, you will have to deal with that. So there will be a decision at the end. And the child maintenance is based on the child needs, of course, but the child needs can be, there is discretion on that too, because it will depend on the lifestyle of the family or of the income of the parents. And the court can decide, or the parents themselves can decide that the contribution, the children maintenance, can take different forms. It can be a monthly payment, most of the time this is it, or direct payment of some specific fees, for example, the school fees, or activity, health insurance, etc. And it can also be a right of use and habitation for the parents who has the children with him or her. And what can I say more? I think.
How is it calculated? Is there an official calculator as well, or is it the discretion of the parties?
No, there is no official calculator. There is some tools provided by the government, and there is a website when you can calculate your maintenance, but in practice we use it as a reference, but it's not always adapted. It depends on the cases, and it's usually inadapted for higher income.
Okay.
And as I explained, in most cases we will decide of an amount of maintenance, but as well with the payment of the school fees, which adds to the payment. So, and the calculator, the public calculator, doesn't take this into account. So it's just a reference we can use, but the court is not binding by it, the parents either. So.
Okay. And then another difference that we had discussed was how long child maintenance is paid for. How does it work in France?
In France, the rule is that it's due until the child is financially independent. So that lasts for a few years. It depends on the studies of the child, but it can last for many years.
And in England?
You can go back to the court if there is a change in the situation, or the parents can agree to revalue the maintenance. But the maintenance is still due.
Yeah. Rachel, how does it work in England? When does it end?
It's on the child's education. So the child maintenance services until they're 16 or finish their full-time secondary education, so they're after that it's the court that has to deal with child maintenance during university.
So something to take into account, because in France, I mean, if you've got a child who doesn't want to move out, they could be there not financially independent for quite a while. 16 is a lot younger, so something for people to consider as well in this decision. I forgot to say at the beginning, but it goes without saying, please, anybody who's on the call, feel free to put any questions you have in the chat. We'll be more than happy to answer them, whether they're relevant to one jurisdiction or both. We'll be really, really pleased to be able to answer your questions and make sure that everything is as clear as possible. As I said at the beginning, this is a decision that has many, many facets and a lot of things that need to be considered in making this decision. Definitely understanding the law of the land in all the relevant jurisdictions is going to be key, but also understanding some of those smaller details, because if you're in a situation where there's a massive pension pot or you're about to retire, it might be that you choose one jurisdiction over the other because you want to benefit from the different treatment of pensions. Same with spousal maintenance or prestation compensatoire. All of those factors will be more or less important based on your specific situation. So it's not an objective, in this, France will be always better than England or vice versa. It will depend on your situation, and that's why that conversation is really key. And speaking to a solicitor or a lawyer in both countries is key, and working with somebody, whether it's a divorce coach like myself or anybody else, to try and look at all of the information at hand to make an informed decision will be really important, because it will be, the law that will apply in the context of your divorce. So it's something to really think about twice. And one thing to think about as well is, where do you intend to live in the long term? Because having orders that are locally binding is going to be quite helpful as well. So if you're planning on living, moving back to France, if you're living in England and you're moving back to France upon divorce, maybe France makes more sense because that's where you're going to be, that's where your children are going to grow up. And so you'll have more access to legal support if you need to in that jurisdiction. I don't know if there's anything that either of you want to add, Coline or Rachel?
I was thinking about one thing I forgot to talk about. It's the devoir de secours. It's regarding the spousal maintenance, but I think it could be an important difference because in French law, when you file for divorce, you will have a spousal maintenance during the procedure. It's the goal of it is not to let one of the spouse without any resources during the whole process. So it's based on the spouse needs, and it's a monthly payment or a right of use and habitation. And the ground of this spousal maintenance is different of the ground of the prestation compensatoire I talked about earlier. So it's different criteria, different grounds, but it's a very important thing in French law because you are not without nothing during the procedure, which could last 4 years, and sometimes it gets tragic to make the procedure last because of it.
Yeah.
But,
yes. So is it systematically looked at the start of the procedure? Any kind of maintenance is looked at systematically?
Yeah, this is automatically looked at it because, as for children consequences, as for the spousal maintenance, there is a check of everything. Mm-hmm. But in some cases, it won't be needed. But if it is, we will have one.
Whereas in England, Rachel, it needs to be a specific request to the court, right?
Yes. Yeah. It's a separate application or done by, but the court has power to order interim maintenance, also order one party to pay the other party's legal fees.
Yeah. So it's a similar concept, just applied slightly differently. So I haven't seen any questions go by, so I assume we've been very clear and we've answered everybody's questions. But Anybody who has any follow-up questions, feel free to reach out to Coline, Rachel, or myself. Our Instagram handles are in the advertising for this event, and you can find us on Instagram and contact us through the messaging service there, or online. You can Google us and find us, and we'll be more than happy to answer any specific questions you may have. Any last words before we part?
No, I think we talk about everything we plan for.
Great.
Thank you, and sorry again about my son, but thanks for having me.
Thanks for
I'm sorry for my English, because I know it's not completely fluent.
Great, and we'll do the next one in French. We'll give you the Thank you all very much for joining. I'll share the recording after the event, and all of you
Thank you too.
Can share. Thank you so much. Have a good evening.
Thanks. Bye.